Some people walk into court thinking they can outsmart the system, but Judge Boyd isn't having any of it, and these idiots learn that the hard way.
We hope that that's not what the court decides to do, but if the court decides, we ask the court to follow the plea bargain and perhaps give him 3 years.
Kicking things off, watch as Judge Boyd quickly shuts down this defendant's attempt to wiggle out of trouble. He skipped court, then tried spinning a story right to the judge's face. But let's just say, Judge Boyd wasn't buying.
He got picked up and asked you to consider a bond and getting him out. We left him in there on purpose to pay his penance. And we're asking you to follow the plea bargain if you would.
All right. According to the plea bargain agreement, punishments be assessed at 2 years in the prison. There's a $500 fine. And it says that both parties agree that if he didn't show up for sentencing, he would be subject to the full range of punishment. So State, are you still proceeding with the plea bargain agreement?
Your Honor, in light of him not showing up, I believe the full range, as it says in the agreement, at this point, we'll defer to the court for the reasoning behind that he didn't show up and if it was a valid reason.
Right. You want to call your client as a witness to explain?
Yes.
Could you raise your right hand for me?
Raise your hand.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record. State your name for the record. All right, why didn't you show up for court?
Because I have some problems.
We all have problems, but you're not telling me what your problems were.
Well, first of all, my daughter had her baby, but I came up with I was sick too, so my corona.
Everybody used coronavirus as an excuse, but did you provide any medical documentation that you had that?
I have that.
No. Did you provide any medical documentation to the court that you were ill?
I think I did. I should have. Do you have any?
I do not. Not for the date you're addressing, Judge.
Yes. So you did not. Because if you would have, I would have that. And I don't have it.
So you don't have any paperwork at all?
I don't have anything to show that you were ill, and that's the reason why you didn't show up for your sentencing. I do have that I was lenient with you to allow you to get your affairs in order and to come back on a different date for sentencing. That's what I have. So why shouldn't I sentence you to beyond the 2 years? Because that's your agreement. Your agreement is if you don't show up for sentencing, you are subject to the full range of punishment. So my question to you is, why shouldn't I sentence you to 20 years?
Say that again, please.
Your agreement was that if you did not show up for your sentencing date, that your range of punishment would be up to 20 years in prison. You did not show up. So the question is, why shouldn't I send you to prison for 20 years?
He looks completely baffled, like skipping court was just another casual errand. But Judge Boyd wastes no time reminding him that blowing off a hearing isn't exactly a free pass.
I most definitely didn't understand that one.
No, you did, because it's a part of your plea bargaining agreement. And what I can tell you, and I'm sure your counsel will tell you this, and even though this is a new prosecutor to this court, I go over the plea bargaining agreement in great detail and ask on the record, do you understand that to be the plea bargain agreement? And usually, well, not usually, every time I ask the defendant first, do you understand that to be the plea bargain agreement? And they will say yes. Then I will either ask the state of the defense attorney, is that the plea bargain agreement? And I can tell you that you were aware that you were subject to the entire range of punishment. So we're back to this. Why shouldn't I sentence you to 20 years? Because that was your bargain, that if you didn't show up for court, that you will be subject to the full range of punishment. And I remember all of the people who say, give me some extra time and I will show up.
She have a baby next month or whatever, you know what I mean? But I don't think.
What do you mean she has her baby next month? You told me she already had the baby.
No. She went in the hospital. She was sick. I thought that she wasn't going to even, that she was going to lose the baby or whatever, you know what I mean?
And when did this happen?
Like last month.
All right, so that happened last month, so that would have been January. So that still doesn't explain why you didn't show up for your sentencing on November. You were set for sentencing on November 3rd. Here's the thing. Sometimes people don't have an excuse. Sometimes it's like, I made a bad decision. I was enjoying my free life out here and I just didn't show up. So I'm trying to figure out, is that your case or is there something else that was going on in your life? Because you're looking at 20 years in prison.
It was at this moment he knew. He f***ed up.
That he doesn't have an excuse that we want to offer at this time. He does. I mean, I agree with the court. You did admonish him. He understood that. I'm concerned. I mean, as we stand here today, he's not near as cognizant as I've dealt with as he's been in the past. I'm somewhat concerned about that, but he's not a man of means. When that November date came, his phone was cut off. We were not able to locate him. I mean, he didn't. I mean, I know I spoke to him after that when his daughter was sick, but we'd ask you not to sentence him to 20 years. We don't think that's, we hope that that's not what the court decides to do, but if the court decides, we ask the court to follow the plea bargain and perhaps give him 3 years.
The look on his face when things don't go as planned, absolutely priceless. He thought he had it all figured out, but Judge Boyd had a very different plan in mind.
I've been indicated that the court takes this seriously and
All right, state.
In lieu of the explanation of the judge, the state, with previous negotiations that they have in our file, we believe the appropriate sentence would be 5 years. 2 years.
All right, this is what the court is going to do. 4 years in the prison, give you credit for any time served, take in consideration 2021 CR 2207, 2021 CR 1465, 2021 CR 2771. The court will give you credit for any time served. There's a $500 fine. Time and money will run concurrent. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
that's your signature.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? We can go off the record. Mr. Carroll, I always, when attorneys say, can you give my client some extra time to report? Sometimes I do, sometimes I don't. But I take it very seriously when I give someone time to report, because when you think about it, somebody's saying, all right, I'm going to show up and I'm going to take my prison sentence. You didn't show up. And that's a problem. And if there would have been a good explanation, things may have turned out differently.
Judge Boyd handed him way more than he bargained for. What started as a casual attempt to dodge accountability quickly turned into a harsh reality check, 4 years behind bars, and a $500 fine to top it off.
So let me explain something to you.
Next up, we have a sovereign citizen who makes his grand entrance wearing jail scrubs and handcuffs with a felony handed down by a grand jury. But instead of facing reality, he's busy arguing the court has no jurisdiction. Well, the judge was ready to deliver a reality check.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance. Under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? Mm-hmm. All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you.
The defense attorney was handling it brilliantly, walking a fine line that showed she was advocating for her client without ever crossing into endorsing his wild claims. That's some masterful lawyering right there.
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code and There's a list in the penal code of all the crimes. And aggravated robbery is one of those crimes that's listed in the penal code. And it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment. And the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling?
Judge Boyd didn't just rule, she shredded every single claim this man threw out, leaving him absolutely silent in his handcuffs.
Charged with an abstract offense. See, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the Seventh Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to, being a third party brought in here without, abstract subject matter jurisdiction. And, the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge reverting, I guess, the Seventh Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? Explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am. I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecuting me, which is they're the one of third party,
Okay.
and I'm not. I don't. Third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant.
Every single one of his motions was pure word salad, legal jargon tossed together with no meaning at all. Honestly, the biggest surprise is that Judge Boyd was able to make sense of it in the first place.
It says, objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues.
If you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
Dude's standing there on an aggravated battery charge and he's trying to run the old no power routine? Bruh. There's an actual victim in this case. It's not exactly the time to make believe law school arguments.
There are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's, again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else?
Judge Boyd handled the situation with patience and respect, even when he deserved none, before tearing apart ever baseless motion like Pro. One of the cleanest takedowns you'll see inside a courtroom. And that wraps it up. Judge Boyd proved once again that no amount of arrogance or fake legal jargon can stand up against real authority. These entitled idiots walked in confident, but they left humbled. Let this be a reminder: when you step into Judge Boyd's courtroom, you better come well versed in your rights.